But when I began to interview my female colleagues, it became apparent. I mean, out of 60 women that I interviewed, 59 reported some form of bullying, harassment, sexual assault, up to and including allegations of rape. And after about 4 or 5 of these interviews, I went back to my supervisor and said, because this was not the focus of my research, but it turned out to be a very important component of the doctoral thesis, and it has led to a dignity charter, a proper equality statement, mission statement, and equality policies for the Defence Forces. But I suppose what I found most on a personal level was the behaviour of the military authorities when the results of the research made their way into the wider public domain, and when they were reported on in the print media. The military authorities embarked on a systematic strategy of character assassination, and I went from being at the heart of the organisation, and I'm sure this sounds familiar, Eugene, to being an outsider, a pariah. And at that period of time, I was on probation as a lecturer. I was on my probationary period. My academic qualifications were being called into question on the public airways, and I had to explain myself. And I thought I was going to lose my job. And eventually, we had to get help. Such was the sustained nature of that campaign of character assassination. Now, as a soldier, I served overseas in a very, very busy operational tour when the Israelis came in and murdered hundreds of Lebanese civilians around us. 500,000 people came through my checkpoints. I was shelled, shot at. I was involved in a number of standoffs, confrontations. But to be honest with you, the trauma of being isolated and singled out for whistleblower reprisal, that has been one of the most traumatic things I've ever experienced, and it's an experience I'm still trying to make sense of. And so, to protect people in organisations, whether they be in the public sector, in government agencies, or in the private sector, in the commercial world, I think it's very, very important that we have this legislation. And if this, myself and Eugene holding a silver whistle outside Leinster House, if that in some way raises awareness of this issue, and if it prevents somebody else having to go through this, the grinder, as it were, then I think it's very, very worthwhile.
Thanks very much. I'm going to open this up to people because I know a lot of people have questions. Eugene, can I just ask you specifically in relation to the idea of a banking inquiry, which presumably you would be called to give evidence to, but would you be confident that the shock that's been delivered to the system has created a significant culture change within banking, such that if people were called to an inquiry, they would actually be completely open and honest and tell the full truth?
No, I think that's a very good question, Fintan, because in my view, it seems to me what the banking industry, financial services are doing is recreating the past at a very rapid rate of knots. And I met a very interesting man last night who was the captain of a large oil tanker, and he described it to me as if his oil tanker had crashed on the rocks, and he was then setting out to sail right again with this massive gash in the side of the tanker, assuming that everything was going to float as normal. And it's clearly not. We have a massive problem in the financial services. We need to identify what the problem is, and we need openness, transparency, to be able to identify what that is and put it in the proper systems. It's not the people, I think, it's the systems. So the system operates to make sure we don't sink.
And I mean, there is, within banking particularly, one of the extraordinary things, I think, for people looking at it from the outside is that you have professional systems, and you also have outside auditors, for example, who seem to have seen nothing. I mean, how do you explain people who are professionally trained, who have codes of ethics, who are highly intelligent people, who presumably are very competent? I mean, at a basic level, they know how to do their job. I mean, what happens to people when that they look at situations which were quite grossly obvious in many ways, and they can't see them, or they refuse to see them? What do you think happens?
Well, I think that's a huge question, but I say part of the answer to that is I heard an interview last week with a woman called Barbara Ehrenreich, who's written a book about recovering from breast cancer, and she described this culture of the positive and she said that some of the reasons for the American banking problem was that everyone believed the sort of, yes, you had to be positive. You couldn't say, no, this isn't quite right, otherwise you weren't on the team. And she related that to her issues with breast cancer, where studies show that being positive with breast cancer makes absolutely no difference to the outcome. But this culture has overtaken business coming from America, and perhaps we've got some of that here as well. So you have to be, it's healthy, I think, as you said earlier, but it's actually beneficial to outside investors, and it's beneficial to the companies that people can disagree in a way that is still positive, but to chart a better course through these problems.
Thanks very much. Is Andrew Sheridan here?
Andrew is here,
yeah.
But we didn't have a space for him at the table.
Andrew is the legal advisor to Transparency International. Would you like to just say a couple of words around what kind of legal regime Transparency International is recommending in relation to meeting some of these questions out?
Andrew will need a microphone.
Oh, of course, sorry, Tom.
I'll try to speak briefly, but I think the best way to address that question might be to state the whistleblower protection regime as it currently exists in this country. We have followed what is called a sectoral provision, which essentially is a piecemeal provision of whistleblower protections. There are over 10 in different statutes, but the genesis of them thus far has been 3, I would say, in reaction to scandals. There's one for protecting people who report child abuse. There's one for members of the Gardaí, even though it's an example of mal-implementation, because it's very deficient, which obviously is a reaction to the Morris report. And then there was a third in the Health Act, which is probably a reaction to some of the people in this room today. Then all the other provisions are provisions which have been attached to legislation which has created new oversight bodies for specific areas. The Health and Safety Executive, the Health Information and Equality Authority. These are all new public bodies which are given specific remits, and whistleblower protections have been bolted on to these areas. But I suppose it's where they're absent is the most indicative. I was speaking to Eugene earlier. The one new public body created during that period which had no whistleblower protections attached was that act which created the financial regulator. It's extremely telling that it had become the norm to bolt it on, but the one anomaly is the one which essentially has us in the mess where we are today. The regulator was set up in 2003. Obviously, Eugene's story with the old regulator, the central bank, was obviously extremely live then, but unknown to anyone but the parties involved. But the parties who would have been lobbying for the legislation obviously did know of the case. I do know that I spoke to people close to those who were responsible for shepherding the legislation through the Oireachtas, that it was subject to some of the most intense lobbying of any legislation that there has been. There is a pattern here. I suppose the second area which we highlight in our report, which is not covered, is offences under company law. It's clear, obviously, the activities in Anglo-Irish Bank. One could say in Fife's DCC, that there is a problem in corporate governance in this country. A lot of cronyism in the country or in the corporate world here, but the Company Law Review Group, which is the group charged with reviewing company law and whose recommendations are generally enacted, looked at the area in 2007 and decided against it. You can see their annual report in 2007, which is, I think, again, Eugene agrees with me, a monument to circular and specious argument. Their essential argument was that there's no problem here. To enact whistleblower protections would suggest to outside observers that there may be a problem, and this in itself would become the problem. I would write, and I did write in the report, that at the time it was a rather suspicious statement to make, and reading it today, it just provides sort of dark, ironic comedy.